Welcome to this session of Unit Chambers Family Law and More podcast. I am Lyana Chan, consultant barrister.
And my name's Callum Hurley. I'm also a consultant barrister at Unit Chambers.
We are pleased to be joined today by Chambers CEO and senior consultant barrister Lisa Edmunds. Thank you for joining us today, Lisa.
Thanks for having me.
In this session, we are going to discuss the Public Law Outline, which has been relaunched by the President of the Family Division, Sir Andrew Macfarlane, on the 16th of January of this year. To kick off this session, Lisa, would you provide us with an overview of what the PLO is and what it's trying to achieve?
Yeah, so PLO stands for Public Law Outline, and as you've said, we've had a relaunch of it this year, and that comes on the back of COVID, because as we all know, COVID has caused the family justice system to clog. We have too many cases. Cases are taking too long to reach good conclusions for children. So the PLO has been reinstated. It was launched many years ago with two desires or two objectives. The first was to prevent cases coming into the court arena. So ordinarily, where local authorities might have child protection concerns about a family, and they would look to manage those concerns within their own forum, with the intention of bringing matters back down so proceedings weren't deemed necessary. But the second objective is that if proceedings were deemed necessary, that the local authority was starting those court cases with what we're now calling match ready. So all of the assessments would have been completed before the application was made. So when we talk about assessments, we're talking about parenting assessments, viability progressing to full fostering, special guardianship type assessments. So the authority land knowing what their care plan is, which means in terms of responding to that, it should be a much quicker exercise. It should mean that the process is more effective and efficient. And that then ties in with the framework of the PLO, which really sets down that there should only be 3 hearings within that process.
Yeah, and I think something that's really interesting for me is, now the expectation is to just have 3 hearings, so the CMH, the RH, and also a final hearing if things can't be resolved at the RH. But what the exceptions are going to be for that, and I think there's probably, I would say, 3 broad categories as to when cases may go beyond the 26 weeks, and that has to be extended. So the first would be those cases that involve complex medical evidence, so where we're going towards a finding of fact hearing, for example. Also where something unexpected happens, such as, those cases where we're going on issues of neglect, but then, for example, allegations of sexual abuse arise, but also those where there may be a litigation failure by a party. And I think that's a really interesting one, because that then links into the non-compliance courts and what's sort of new and fresh and happening with those. But I'm just curious, Lisa, if you think there's any more exceptions or where we're heading in terms of compliance with the 26-week limit.
So I can remember 15 years ago when we had the PLO first time round, and one of the areas for why it failed, in my view, was due to the family members that would come into the arena or round the table and say, actually, I want to be considered as a carer for this child or these children. And I still think that is something that is going to be a real focal point and potentially a trigger for extending the 26 weeks and taking that into the category of exceptionality. Because in my experience, you find lots of genuine human reasons why family members surface at the 11th hour. And I think it takes a very brave judge when faced with the alternative of placement outside of the family. So by that, we're talking about adoption, to say to that family member, sorry, you might have been good enough if you had made yourself known 11 months ago, but because you're only putting your hand up now, it's a no.
Yeah.
So I think you're going to have real emotive and human-driven applications that will cause the 26 weeks to scupper. Whether there's any others, I don't know, because I think at the moment, whilst we're in what may be described as the honeymoon period of the PLO, and again, I think that was one of the failings last time round. It just didn't sustain itself, and possibly need to do a deep dive into why that was. But I think whilst we're in the honeymoon period, we are surrounded by judicial-led desire and influence to very much say it's 26 weeks. And I think we're going to get a lot of kickback. And naturally, there'll be those cases where parties or advocates seek to challenge the decision not to take their case into the exceptional category. And no doubt our understanding about how the PLO is to look this time will become far more informed when that happens. It's
going to be quite a culture shift, isn't it? I think the phrase was used that it almost become built in as almost habitual, the way we were working, and then that you get comfortable in a way. I think we all got comfortable, and I think it's right that there's this relaunch to focus all our minds back on actually what's the focus here, what's important. It's about getting the right outcome for a child, and that needs to be done in as quick and streamlined a way as possible within the 26 weeks, shorter if at all possible, because as we all know, delay is harmful to children.
I think the other problem we're going to encounter as professionals on the front line is the consistency amongst judges. I think we're going to see a real divergence between how one judge on level 1 deals with it compared to another judge on level 2.
Yeah.
And again, that will, I think, make it interesting, if that's the right word.
Yeah, I mean, certainly I have had experience where I was proposing a timetable, but it took us outside the 26 weeks by about 5 days. And that was, so we put forward 2 proposed timetables, if you like, that there was the preferred one from the local authority perspective, in that it gave them slightly more time to complete an assessment. And that was them saying, we're trying to be realistic, really. But then the other one was a timetable that fit within the 26 weeks, but with the option, obviously, if it gets to if it comes to the crunch and we can't actually meet that timescale, we'll have to then file a C2. So I was on my feet and I made these submissions to the judge, and on the basis that, if we're being more realistic, the timetable that took us slightly outside the timetable would be the better timetable, because it would allow the assessment to be completed in a way that allowed the social workers the time to do that. But I was quickly pulled up by the judge who, rightly so, reinforced the need for us to now be readjusting our minds to the whole, no, we've got to be working within the 26 weeks, and there will need to be a way in which everyone has to just change their way of working, and if it means reducing the time to complete an assessment, then so be it. But that's what we all need to do now. So yes, I was quickly put in my place, but I agree, it was right to do so, and it's a culture shift.
Yeah, well, I think reframing is probably a good description as to what we've got to do, but that's got to come in partnership with those on the ground that are doing the assessments and are being told, actually, your culture has got to shift. So you've been used to for many years now having, let's say, 12 weeks to undertake a parenting assessment, and now the maximum you're going to get is 8 weeks, and time will tell whether on the ground that is a realistic objective that can be delivered, because that's the start point. And if that doesn't work, then it doesn't really matter, I don't think, what we're saying or doing in court, because that first component, if it fails, then it just contaminates everything else that stems from it.
On the next episode of Family Law and More, Lisa, Callum and Lyana will be doing the deep dive into Part 25 applications for experts in children proceedings. Subscribe so you don't miss out.
Thanks for that, Lisa. That's really helpful. If we can move away from those sort of exceptional cases, obviously for all other cases, there is the statutory requirement to complete the proceedings within 26 weeks. As the former president, Sir James Mumby, said, and it's quoted in the president's view of November 22, it can be done, it must be done, it will be done. And we know that it can be done. Certainly by 2016, the national average for completing care cases had reduced to 27 weeks. And that was compared to a previous average 10 years before that, where it was taking 61 weeks to complete care cases, so significant reduction. And of those cases in 2016, 62% of the 24,150 concluded cases finished within 26 weeks, which is fabulous. So that's just evidence that it can be done, and we need to ensure that that now starts happening, that it's not the exception to the rule, it is possible. So what happens when things don't go according to plan?
Yeah, so I think one other interesting issue within the relaunch of the PLO will be the non-compliance courts that have developed now. So we know it really stems from our family leadership judge, Mr. Justice MacDonald, who essentially said that each local court needs to set up a list of non-compliance. And it'll be interesting to see where that really takes us. It's quite new. It only came into practice on the 16th of January this year. But essentially, it's an expectation that the relevant professional, the manager and the solicitor of conduct will attend court and explain why the order wasn't complied with, the steps taken to try and mitigate the impact of that default, and steps to ensure that won't happen again. But as I say, it's quite new. I'm just curious what everyone else's view is on whether that is attainable going forward.
Well, I agree with you. I think it's going to be interesting how it plays out because, again, going back to those key workers, those key stakeholders that make everything we do possible. So we're talking about your frontline social workers in particular. Morale is a big part of what they are currently experiencing. That feeds into recruitment and retention. And in my experience in recent times, there's a significant shortfall of good social workers, good family support workers. And where there isn't a shortfall, there's a high turnover. Too often we're hearing from families that within, say, 26 weeks, they've had to engage with 3, 4, 5 different social workers. And I think that is something that is overlooked. But then when you have got social workers that are trying to keep it together, almost a stick and plaster on a broken leg, and they're having to carry the team that is short on numbers, if they're then being taken to court where they feel or their perception is that it's a telling off exercise, it's going to be really damaging, I think, or potentially damaging to the whole morale, recruitment, retention policies that no doubt local authorities are working hard to improve on at the moment. I know that isn't the intention of the non-compliance court, certainly in the areas that we practice. The desire is to better understand where things are going wrong, how things are going wrong, with the intention of then identifying the solution to put it right and put it right permanently so it doesn't happen again on other cases. But I know from recent experience that you've got local authorities, and again, just being really frank, this is going to be targeted at the main to local authorities. And we know that means, as Callum's just said, you've got the solicitor with conduct, the social worker, possible team manager. So you've got 3 key professionals having to divert from their normal working day. So could take the best part of 3 hours end to end because it's an attended hearing in Liverpool. So let's just take, for example, our locality. If you're a local authority that's falling south towards the Cheshire border and you're having to travel, you've got all those factors to take into account, and that's 3 hours away from frontline duty, so to speak. And I just wonder whether there's a better framework that could be deployed that allows that objective of teasing out why things are going wrong, how things are going wrong, how those things are going to be fixed, but without having to assemble those key professionals in a courtroom in person, taking valuable time away from them and potentially making them feel as though at times, they're not fit for purpose.
Yeah, no, I'd agree with you there. And just in terms of the sanctions, has there been any discussion on what the likely sanctions might be, or what the overall, so what will the outcomes be of these compliance hearings, other than obviously sort of a reprimanding by whichever judge is hearing that issue or that non-compliance matter?
Well, my understanding is that the non-compliance court only involves the party who's in default, and there isn't at that hearing any suggestion of going near case management decisions or directions. So the non-compliance judge won't look to adjust the timetable. And I assume, therefore, that would include not issuing any sanctions by way of cost orders, for example. I think the whole ethos behind the non-compliance court at the moment is to go offline with the local authority and to get a better understanding as to why things are going wrong. But the solution to that, I don't know what is intended by the judiciary and how it then filters through into our practice and what we're meant to pick up. And I know there's growing reservation with some advocates that it almost becomes a bit of a closed court. And when you're engaging in public law proceedings, in particular, equality, parity, openness between all parties. So, for example, if there's a non-compliance hearing and the explanation for non-compliance is because a social worker is overworked or feeling overwhelmed or has had some other difficulty, that may be, put it no higher than that, but that may be a relevant factor or a piece of information that those representing the respondents need to know and understand in terms of then analysing the quality of the work that's been produced. And I'm just highlighting that, I suppose, as a bit of a possible example of one of the tensions that may start to creep in.
All right. Well, thanks for that, Lisa. It was really, really helpful. I think if we just end now with our dice game. So let's just see which one you land on. And it's the quick fire questions. So let's see.
What are the chances of that?
So I'm going to try and go fast, see if we can keep up. So, tea or coffee?
Coffee.
Favourite room in the house?
Bathroom.
Worst thing someone could say to you on the underground?
Can I have your seat, please?
Favourite place to go on holiday?
Caribbean.
Biggest phobia?
Rats.
First celebrity crush?
Jason Donovan.
Favourite season?
Autumn.
The best city you've ever lived in?
I've never lived in a city, but shout out to Wigan.
Biggest inspiration?
Grandma Bella.
Favourite ice cream flavour?
Rum and raisin.
How do you like your eggs in the morning?
Scrambled.
Too cold, too hot?
Too hot.
Best restaurant you've been to?
McDonald's.
Worst thing a client has ever said to you?
You're too young.
Who is your favourite member of the Beatles?
Paul McCartney.
Who would play you in a movie?
Ruth Wilson.
If you could visit any period of time, when would it be?
1997.
Oh, that was the year I was born. Just an interesting fact about me.
Showing our age.
Favourite animal?
Horse.
Best thing to do at the end of a hard day?
Lie in a dark room.
All right, well, that concludes our podcast. Thank you for joining.
Oh, thank you so much.
Thanks, Lisa.
Don't forget to subscribe to Family Law and More on your favourite podcast platform. Don't forget, if you have any questions, to get in touch at podcast@unit.law.